How are you doing today? Is it Monday or is it Tuesday? It's Tuesday. It's a short week this week. I got my sidebar shirt on that I got from Jimmy. It's appropriate today. Lots of sidebar in court. One witness, kind of dry. But we got the right guest, so let's just bring him up. Attorney Mark Bederow, and this is supposed to be the star witness today for the prosecution. It didn't seem like he was a star to me. Let's see what Attorney Mark Bederow thinks about today, because this was a long, short day as usual. A lot of sidebars, a lot of delays. Attorney Bederow, how you doing today?
How are you?
Good. What did you think about today?
It's pretty weird. He's supposed to be their big witness to finish strong. He's only still on direct, and so far it's been not good on the ultimate issue about trying to use his credentials to establish a pedestrian SUV accident. And he apparently, if I understood him correctly, did this by looking at interviews that Karen gave, looking at police reports, relying upon the very credible Massachusetts State Police in terms of how taillight pieces were recovered and everything else, and then putting on an outfit to look like John O'Keefe and finger painting, essentially. And that is the sum and substance of his opinion for why the arm injuries were what they were. And then he kind of whipped out a chart, if you will, and kind of said, took a crash test dummy and just had him fall flat and said that must have caused that. And to a reasonable degree of certainty, this is where we are. Wow. I don't, it's kind of stunning, actually. And the dichotomy between them and the ARCA people is so different, because the ARCA guys, they used something called science. It's called science, physical hard science, to explain their reasoning why they have an opinion that there was no pedestrian SUV strike, as far as they're allowed to say that. And all it does is reiterate what I said last week. They should be the first witnesses out of the box for the defense. There's no question in my mind they should come out with these guys right away and just put this to bed, and then go into that path that we talked about with Proctor and Higgins and whatnot. And I don't know if they're going to do this or not, but I mean, we could talk about this later, but if there was any doubt about calling Higgins, I would definitely do it now, because he's going to say my Jeep was there. And that doesn't fit with what this guy was saying today, as far as I could tell, based upon going 87 feet, screeching in reverse. And at the end of the event, if I understood him correctly, it was still 24 miles an hour, and it doesn't stop. That's just when the event stops. So she would have kept going and going. And if it would have stopped short, then her brakes presumably would have been screeching loud. Somebody would have heard, seen. I don't even know what to say. What that was bizarre today. And that's just direct. And he hasn't even been crossed about being a senior vice president of this company, which he said he was aware of the resume issue, and he kind of got twisted around in a voir dire about whether he looked at email or he didn't. He's going to get crossed about also, like Burgess, amending his report mid-trial because the DA asked me to. How's that going to play in front of the jury? I just think this is supposed to be their best witness, bar none. He's relying on data from Burgess to the extent he's relying on any data at all that is actually scientific, as opposed to what the police say happened and what he took from Karen's interviews. And to me, he's a classic example of a so-called expert who has that confirmation bias and has that tunnel vision that you don't want them to have. And, it looks like he was influenced by the other evidence. And then he started saying, the way he was describing it, it was as if he was trying to make it fit what they wanted, as opposed to just being completely agnostic and doing real experiments and real things and just coming up with an opinion. And if what you're going to do is dress up like John O'Keefe and put paint on a taillight and then pretend to get struck at 2 miles an hour and then turn yourself, but then he turns into it.
That's the craziest thing I thought about, like the 2 miles an hour. Once I said that, I was like, "This, what do you mean? Like, this is ridiculous."
It's not even the worst part of it. I mean, he says, I don't know where he was hit. I don't know how he was standing. We don't know any of these things, but I'm just going to stand here like this in a way that will slowly roll me across the car and get, and then he puts on, he puts on all the clothes, but when he does the experiment, what does he do? He takes off the hoodie. So what the hell is the point of this? Unless it's just trying to, make the jury feel bad. I don't know. The difference between this company, Aperture, and ARCA is just whatever gap you thought there was after Burgess, it got wider today, I think, because there was very little actual science to explain why he thought that there was an impact between a pedestrian and an SUV, other than, well, it all lines up with the paint on my arm. And so I believe that's what happened, and things of that nature. But what about the taillight? I mean, you're an accident reconstruction guy. Tell me about polycarbonate taillights and tell me how it essentially exploded. He said earlier in his testimony that because John O'Keefe was 216 pounds and it was kind of a low impact, in his mind, accident, it's not surprising, or words to that effect, that there would be no triggering event, that it was just kind of a blip. That's what he said on direct, which kind of begs the question, then how the hell did the taillight explode when it's made of a material that is designed not to explode? If it is going to break, it breaks within, it kind of indents. And he apparently on direct isn't even going to be asked about any of this. And so he's going to get vigorously cross-examined on the substance. He's going to get vigorously cross-examined on Burgess and that whole fiasco. He's going to get vigorously cross-examined about changing his opinion mid-trial because Brennan asked him to, the way Burgess did. I mean, how do you finish up like this? Which is all the more reason why they should come out swinging with the ARCA people right away.
We get to the more on the cross because I think you've just laid it all out already. Why do you think Brennan did the same thing with this witness that he did with Burgess? He didn't try to clean him up at all. Didn't try to address any of what's coming.
Well, you got to dance with the one you brung to the dance, and this is who they found. We don't know why they came up with them, but this is the guy that they got to replace Trooper Paul, and just for good measure, he mentioned Trooper Paul as well. I mean, the guy actually opened the door. I don't know if Bob's going to do this or not. I don't, know if anybody wants to be there for 3 days, although you could see him doing that. By saying he relied upon all of these interviews, you could try to rehabilitate those interviews that Brennan's been playing clips through him and ask him if he saw this. Did you see this clip, or did you see more? What more did you see? He could ask him about Trooper Paul's report and, point out to the jury that this is not their first try at doing this. He says he relied on the taillight pieces being found. He could be asked, were you aware that they were found over the course of 3 weeks, and da 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 da? And were you aware that there was glass on the bumper? And did you Are you aware that that glass doesn't match with John O'Keefe? I mean, if you wanted to do all that, he said that's what he used as a basis for his report. So this is all fair game to the extent they want to do it. I don't know if they will or they won't, but I mean, this guy was just, it's shocking how bizarre it got at the end. I mean, it's just, you know, I've never seen anything like it. I mean, it was literally, we're using paint and just dressing up like him and rolling across the car and saying, look, it matches. How many times did he do this experiment, by the way? I don't know. Did he do it 3 times? Did he do it 4 times? Did he do it 1 time? Who the hell knows? But how is this proving the vehicle strike that is supposed to be the homicidal act? I mean, he said nothing really scientific about it other than I could roll across the car, and he pulled out a chart to show head injuries that, you know, apparently to him were consistent. He's not even a doctor. He could have been, but he didn't want to be, apparently, or his father didn't want him to be.
His father didn't want him to be, so he decided to go into what was it, engineering or something?
Yeah, I don't think his attempts at humor landed very well either. I mean, it felt very contrived. Not that that's the biggest deal in the world. It just didn't come off to me as very smooth. It felt very canned, and you know, I mean, the impression I got from really both of these guys, but more so today. I mean, Burgess, I'm still stuck on the academic stuff. That this was a very stereotypical expert in a civil case who gets paid and comes up with an opinion. And, you know, if you need the opinion, he's going to give you the opinion. He just, and maybe that's just me, but he came off to me as a classic hired gun expert who will conform to do whatever it takes based on whatever, because he really didn't do that much as it related to the car accident. I mean, to me, the impression I got is that he spent more time on the John O'Keefe car issue than he even did on the ultimate issue of trying to persuade the jury that, you know, Karen ran over John at a high rate of speed.
Definitely. A couple things I want to put up on the screen. Let's put this one up first. Actually, that's the wrong one. I don't want to start there. I want to start with this one. This was about, you know, what we were talking about with the paint. Purple Kool-Aid Drinker says, guess what, guys? This expert left a very key part out of his reconstruction. A Lexus, blah, 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 air suspension lowers 2 full inches when parked. It's 2 inches higher when moving. Take all his measurements and throw them in the trash as if they mean a damn thing anyway. Did he say anything about that? Whether the measurements were standing still or moving?
I don't think he said either way. I think my recollection is that he claimed that the portion of the cars that would have struck would not have even reached to the level of her taillight, the one that was cracked, is what he said.
2 inches could maybe make a difference. I wonder if that might get brought up tomorrow. That's something that maybe could get brought up, you think?
I mean, if it's true, yeah. I mean, I'm not aware. I mean, I'm not
Yeah,
a car expert. I'm not, you know, I'm not Mona Lisa Vito. I don't know anything about cars. And
yeah, I don't know about the Outlax 570 either.
Right.
But those cars, that's the type of car that seems like it does actually. I've seen some of those cars that go up and down.
Point
I know
is,
what he's talking about.
if that's accurate and he didn't mention it, then you bring it up on cross because you're just showing that that's something you should explain to the jury and account for. And even if he still thinks it doesn't impact his opinion, it's something that should be pointed out because you're supposed to be an expert at this. And if you're not telling the jury about how the car works or how, you know, these things go together, then, you know, that could impact his credibility as an expert just in terms of knowing the subject matter. So I don't know if that matters or not, but I mean, if that's the case, that's something, sure, that's worth 10 seconds across.
This is the other one. It's a two-part. Oh, I thought I had the second part. Well, that's all right. This is the second part of it. This is from another case that where he was a witness, Welcher,
Okay.
and there was an opinion that came down, and it basically said that he went with like discredited analysis, like basically on things that they don't use, and they called it questionable in this ruling. Is that something? And it was in a Massachusetts court case. Is that something that the judge will allow to come in on this or not? You think?
I mean, it's fair game. And, when you look at the highlighted part where you say his analysis is not sufficiently tied to the facts of this accident, the first thing that jumps out is his exercise in painting. 2 miles an hour is a hell of a lot different than 24 miles an hour. He's also assuming facts not in evidence to support his opinion. You don't know where John O'Keefe was standing. You don't know how he was positioned, and he set it up. I mean, he admitted as much, but then said, I'll just do the experiment this way. When he was talking about John O'Keefe banging his head with the crash test dummy, he just dropped the crash test dummy flat. Well, that's not how John O'Keefe would have been. If he got hit by the car, he would have been launched, according to their theory. You don't even know what angle he would have landed on. He would not have gone straight down like that. He would have been at a much more parallel to the ground angle. And, and he doesn't know, and he's doing experiments of just, hugging a doll and dropping it and plop. He told you it's a dummy, but he didn't even explain why it's as reliable as a human head. Just trust me, it is. This is what we do.
Too. This is the other part of the document. He used cadavers, and there are, here it is. Cadaver testing, which is an unreliable method for analyzing how force affects live human beings. So it seems like he was sloppy in this other instance too.
Well, but that's the same point. I mean, if the problem is using a cadaver or a dead body doesn't emulate a live person, well, then obviously a crash test dummy doesn't. And also, wouldn't the crash test dummy have to be 6'2", 216 pounds, and be dressed, instead of putting the clothes on yourself, put it on the dummy? I mean, look, they're going to have a field day with this guy on cross. This feels like that this guy read the case materials, came up in his mind with what he's supposed to be looking for. And although he kept saying, the facts are what the facts are, to admit repeatedly towards the end of the day, when asked to summarize what led him to come to his opinion, and the first words out of his mouth were Karen's interviews, that's not science. I mean, the police reports, that's not science. None of this. The fact that there were, they told him there were taillight pieces on the ground, that's all leading to bias and tunnel vision, perhaps. But whatever it is, it's not scientific. And if the DA thinks that they were trying to establish with the jury that, unlike ARCA, these guys considered all of the evidence, but he overcorrected and went too far, because the ARCA guys are going to use science. In other words, they're going to get up and they're going to say, I didn't look at all this stuff, and I don't care, because I understand physics. I understand hard science, and hard science says, And they're going to say, you didn't look at all this taillight pieces. And he's going to say, I don't care, because the physics is what the physics is. And that's going to be the huge difference. And they're going to, these guys need to be called right away. I mean, right away. But, that's just my view, obviously.
Good number one. Katie's asking, what do you think about Welcher repeatedly calling the judge ma'am? The secondhand embarrassment consumed me, says Katie. What do you think?
Nothing. I mean, she's a woman.
Do you think it? I want to ask this a little differently, because there's supposedly a younger jury. Do you think that the jury might kind of be turned off into, or they don't care about that stuff, do they?
No, I mean, look, I've heard people call judges that are male sir. I've heard female judges called ma'am. I mean, I suppose any particular individual could say, gee, that's weird, but it doesn't matter. I don't think that's anything. I don't even think it's inappropriate. The easy way is just to say your honor and get it over with. And that way you don't, risk offending people. So the real question is, the safe way is just to be neutral and just say your honor. You can't offend that way. But I don't think the jury is going to do anything or not do anything because the witness, I mean, he was using polite language, called her ma'am. But he also came off, I think, is very defensive in the voir dire, which is pay attention to that for cross-examination coming up. He's very defensive, and usually you don't see that in really credentialed experts who are very secure in their opinion. Like, take the voir dire with the ARCA guys from.
Yeah, they were so cool. They were almost laughing.
I mean, Brendan was screaming at them, acting foolish. The words I've used are, swinging from the chandelier, essentially. The histrionics, the gesticulations, all of it. And those guys were basically whatever. This
like
guy,
Tom Cruise and Top Gun, like the Jill instructor trying to yell at him. It's like, good luck. Yeah, whatever.
But I thought that Welcher today was a little, he got a little Buchanic. I don't know if you noticed that in the voir dire. He got a little Yuri in terms of, well, what do you mean? When? What, there wasn't a clear question. He got very, in a way where, as an expert, you don't have to do that. So it's going to be interesting with cross on him.
Yeah, I can't wait for the cross. That's tomorrow, hopefully. Should be short. The last little bit of the prosecution with him. Lauren asked, why wouldn't judge do a taillight experiment?
I don't know. I mean, I think you're better off, doing that by sticking an arm out, not of a person, but if you're going to use dummies, you're better off. You're better off having a car floor at 24 miles an hour and smash into the arm. Now, the cynic in you might say, well, maybe they did do the experiment. It didn't work out so well. Doesn't really do what they want. But the thing that I can't for the life of me understand is how he literally did not address the issue of a polycarbonate taillight and it ending up in the condition that it did. But at the same time saying part of my opinion was formed because I saw pictures from the Massachusetts State Police who basically told me this is how it was found. So in other words, he's essentially citing Proctor and Buchanan as credible sources for his scientific opinion when he could have done science instead, and he didn't. And that's just a joke.
Experimentation. It's so funny. That is, yeah, I guess that's the best they have. This is what they have instead of Trooper Paul.
They have him instead of Trooper Paul, but also don't forget, the jury has no idea that he too backed up, or I shouldn't say backed up, changed his opinion recently, mid-trial, at the request of the DA. They don't know that he is making his current opinions based upon Burgess changing data. I mean, you see it with Brennan all the time. He doesn't bring out the bad part. He just kind of hopes that the defense forgets. I mean, he would have been better off in saying, did your timeline move? And if so, explain how. And just explain, Burgess did this work. I checked it out. I agreed with it. So I, based on what he did, switched my calculations. And after that happened in early May, I did the same thing. Why wouldn't you do that on direct? And by the way, don't think for a minute the jury doesn't see that because Welcher does have academic credentials and degrees, that he spent a lot of time on his direct today asking about those degrees as opposed to what he did last week. So He
Fix
probably
that
wouldn't.
up? I mean, do you
Yeah,
think they do? Because I mean, I know we all do because you said it. I mean, you noted that right away when Brennan didn't
no, no.
ask Burgess for the
Well,
credentials. But
well,
do you think
hold
the
on.
jury does?
The reason why I noticed it right away is because it never happens. It's
Yeah,
always done that way. So it was brought out on cross that he didn't ask you about the credentials. So the way you would bring it out on cross with Welcher is he did ask you. Do you remember you were asked? And I just want you were asked about your bachelor's degree, your master's degree, and your PhD, and you knew he was going to ask you about that on direct, and he'll say yes. He may not fully comprehend what's going on. 18 of those people sitting in the box are going to damn well comprehend what's going on right there.
could you ask why do you think you can't go that far? Yeah, like you can't. I would just think like you would ask the question like, why didn't Hank Brennan ask Burgess about his
Well,
background?
you can't ask. You can't
Yeah, you
ask.
can't. You can't. That's yeah.
But what you can say is, do you recall that he asked you on direct your credentials and say, when did
No.
you prep to testify? Did you prep to testify with him after whatever day? Whatever day. When did Burgess testify last week? Over the weekend? After Tully picked you up at the airport, you went to the DA's office. When you prepped to testify a few days ago, were you asked about this? And you can even say, was that after you got the emails about Burgess? That's fair game.
Definitely.
That's all fair game.
This is how Bederow would do it. I love it. I love to hear because this is good to know. Like how do you get this kind of stuff in there? Like because
To me,
I always think the jury's going to miss stuff. I hear the jury was taking a lot of notes today. That's what Christina Rex was reporting.
what I
What do
get,
you think about that? That they were
nothing.
taking a lot of notes of this.
He's giving very convoluted, dense, in many ways boring numerical testimony about timelines and speeds. They're not going to remember that. So I mean, I think it makes perfect sense that they would write that down. I mean, I don't read into that good or bad, other than the DA is presenting a witness that they think is going to establish that the car backed up at that speed right in front of the house at 12:32 or whatever it is, and they want to remember the actual numbers. I think that's normal.
It's crazy too. Like to think that the car did all of that. Let's just pretend it did what he said. How could nobody in the house hear that?
I think that's a big problem. That's always been a problem, which is, look at what this guy was saying today. He's saying she moved up a good 30 feet, switched it into neutral, put it into reverse, and just went flying. But she gave herself a 30-foot head start going forward
Right.
to come back 80 something feet, 87 feet, up to a speed of almost 25 miles an hour. Um, you've seen the house. People are aware. The house is closed. There's 12 to 15 people inside. Bear in mind, if she goes up another 30 feet from where she allegedly was, which was by the fire hydrant area, that's what Jen McCabe says, right? That area, she'd be square in front of the neighbor's house, not just on the side of the property. She would be literally, off the Albert sightline and come shrieking in reverse, smash into him, and eventually, presumably, slam the brakes on. And nobody would hear or see that when this was happening in the house, in the neighbor's house, across the street, nowhere. Um, I don't know how this explains what, those kids who drove up saw, who said it was around 12:30, give or take, and they saw her just hanging out in the car. And so nobody saw this. Jen McCabe said, "Pull up behind me."
Screaming. Like, come on, because if there was ever a domestic incident like that, there would be
12.
some screaming before it happened and right during probably and while it happened. Even there would have been yelling. Like people would have heard it. I'm just so convinced of that part of it, you know?
And McCabe is looking out right around the time of the incident. Pull up behind me. She says, I saw him. And then, she kept looking out, but heard and saw none of this. If he's going 87 feet, the point of impact at that speed, I mean, I'm not an expert in any of this, but, we all have common sense. Hitting John O'Keefe would have been pretty loud, one would think. Somebody would have seen or heard it. It just doesn't make any sense. And moreover, the prosecution's problem is they have no corroboration for it, and they have the burden of proof. And she almost certainly would have smashed right into Higgins, the Jeep that, the kids say wasn't there. Well, that's interesting. But, McCabe says it was. But more importantly, Higgins at the last trial said under oath, it was there because I was in the house. Now, all of a sudden, where he puts that Jeep is pretty important. And they put it, moving away from the driveway towards where Karen would have been careening at 25 miles an hour, 87 feet. I mean, you're running out of space for all this to happen. This may be why, maybe this is why Brennan didn't call Julie Nagel too. Why would he give up the blob testimony? Maybe he didn't like what she might have said about, Higgins's Jeep and where these cars were positioned and how it wouldn't make sense. I don't know.
Like if this is Hank Brennan's last witness, which it seems like it is, does the defense call do they call Nagel?
No. I would call Higgins.
You call Higgins.
I'd call Higgins for sure. Yeah. I mean, I don't know if they're going to do that, but I would.
Now, there's some information. Looks like that the defense is now asking for new witnesses. It looks like they're friends of Michael Proctor on the text list.
I'm sorry, I was looking at a message I got. I'm sorry, what'd you say?
There was some Michael Proctor had some friends.
Oh, right.
On the text list, and apparently they're on the new witness list.
Yeah, no, that sounds like a tell that they're not calling Proctor is what that sounds like to me. I don't know that, but you don't need the friends to talk about the text messages if you have Proctor. I mean, that's just redundant to the point of not necessary. So that would appear to suggest that they want to get the text messages in through them, and then they'll just leave whatever else they could establish through Proctor out of it. They know what they're doing. Obviously, they know things that we don't and are privy to and analyzing what's going on. But that would be surprising to me. But there's no reason to call the friends if you're calling Proctor. They're just going to say, I got the message. I mean, you don't need to.
Why wouldn't they call Proctor? Because a lot of people don't understand why not. I've been thinking about that a lot. Why would they call him?
Well, first, I don't agree with it, but that's just my view. But there's a few reasons. There's always the risk assessment of if Proctor testifies as a defense witness, then the DA can cross-examine him, which you're cross-examining a friendly witness. So basically, Brennan could attempt to put words in his mouth. I mean, literally testify for him and just have Proctor agree. But the way I look at it, there's nothing that Proctor can do to harm them. I think you put the face in court. I think you stick it to him as hard as you can. And then, you also, there may be other texts that they can't get in through the friends as well. I mean, like the gift to the wife, that I'm not sure how that comes in. That was with, I can't even remember off the top of my head who that was, but, I would be grilling Proctor about how experienced a detective he is and talk about how he's so experienced that he just assumed that this was a hit and run accident just by talking to Jen McCabe, that he ordered a tow truck for the car before he got down there. I would definitely, it's a big deal. The taillight, the lack of a picture, that the Sally Port video in his pocket for 2 years, the inverted video, everything was just inexplicably in his pocket, and he claims he didn't tell anyone. I mean, I don't, you never want to create risk, obviously, and anytime you do anything, you theoretically create risk. But to me, Proctor is house money. There's nothing he can do. There's nothing he can say. He can cry all he wants about how, I'm a different person and I feel terrible about those messages. But I'd want him in front of the jury to admit that he got terminated for exhibiting bias, and let him argue about it if he wants. Let him read those messages like he did the first time, and let the jury know this is the guy that the DA wanted to memory hole. Didn't mention him in his opening, didn't want him to testify. And so to me, that's what I would do. But it appears that they're not going to do it, just based on what you saw today with that witness list. It could be wrong, but that seems kind of obvious what they're setting up to do.
I hope they put Proctor on the stand too. I gotta say, it's funny because Kate Peter was the one that was saying that first. Is that Proctor wasn't on the stand, that his friends were, and you know where that's coming from? It's coming from the Proctors, So she's their spokesperson along with some other people. Uh, this is not that I ever trust anything of hers to be credible, but sometimes it is.
Yeah.
How about this one right here? Nikki says, "Could Proctor not turning over the Sally Port videos, you mentioned that just a minute ago, lead to a valid fifth claim?"
Not across the board. I mean, he did talk about video at the first trial. I mean, you'd really be splitting hairs about whether he's entitled to, tap dance through the minefield about what he previously said about the video and this. That could be an argument. And, if he is taking the fifth, he won't have to come in court and literally assert it on the stand. So might that be an issue that we're unaware of? Maybe. But I would push it as far as I can and make him, if he even wants to make that claim, whether it's valid or not, make him try to do it and argue it.
This one, Dolores says, "Is Proctor unavailable? Maybe he's in rehab." There's been a lot of that online. There's no indication of that.
I
I
don't.
think, yeah.
No, you subpoena him and he's got to show up. I mean, that's
Yeah.
just the way it is. Unless he has some good excuse, you subpoena him. But again, I mean, I think people have to be realistic. If you file an updated witness list at the late game, adding these names, there's a reason you're doing that, and it's to get the text messages in, which you would never need to do if you had Proctor. So to me, it's pretty obvious what appears to be happening here.
I'm not going to say this user handle, but they want me to do a poll to see if Proctor should be called. That's kind of pointless because we know it will happen. 99% are going to say yes, right? I mean, what do you think, Mark? If I put up the poll right now on the YouTube chat, what would be the results if Proctor should be called?
Overwhelmingly, look, people want to see it, if nothing else, for the blood sport of it. Obviously the lawyers who decide these things are thinking tactically, and they're weighing the pros and cons. And if they get the messages out, that's good. But there are things you won't get if you don't call Proctor, but it's a cost benefit. And I mean, I think you have to trust they know what they're doing, clearly. So, they're certainly aware of things that, you and I would not be aware of.
It's a question from Laura. She wants to know, as an attorney, how do you stay calm while you're listening to such lies and misinformation? How will it affect the jury overnight?
Well, I don't know if the jury knows that they were schnookered today. I don't know if they know that it's kind of weird for an expert who is, at core a scientist to say that a lot of my opinion was formed on reviewing the case file and then putting paint on a car and rolling around in it and, dropping crash test dummies on their head. I don't know if they know how bad that is. And you also have to bear in mind, they don't know that he changed his opinion because of Burgess yet. They don't know that Brennan went up to him recently and said, can you change this? So there's a lot coming for this guy that I think will be very bad. I mean, there's going to be a whole line of questioning about confirmation bias and all that. And the evidence of confirmation bias, by the way, as it relates to Welcher, is 1,000 times stronger than it was as it relates to Burgess. I mean, he literally read the case file and all the stuff that is in dispute and cited that as one of the reasons why he concluded what he did. And as far as we can tell, I mean, he's not done testifying, but it appears to be the case. He didn't do any real scientific analysis. I mean, he didn't do any physics, if you will, or talking about the taillight, the injury on him, other than looking at charts and paint. That's not, I don't think generally how accident reconstruction works, particularly where the defense has affirmed who they are scientists and they are totally all in on the science. They will tell you, I don't even care about the taillight pieces. I don't care what she said because the rules of science control. Okay. It's better evidence to have laws of physics than, well, Karen said whatever she said on, HBO Max. Nobody cares when you're a scientist. It's all background noise to a scientist, not to Welcher. He absorbed all the background noise and factored it in. Big difference.
Such a stark difference between the two. Like, one's like a gossiper, and let's not who you trust. You trust science. Like, you trust the facts, not he said, she said. That's just.
Yeah. I mean, one guy's going to say, we built the cannon and tried various things to see what would happen, but they're telling you we were focused on the taillight. This guy ignored the taillight and just, rolled over it at 2 miles an hour and said, look, there's paint on my arm that's consistent with what, the injuries were to his arm. I mean, that's
like that. I'm surprised that he hired Yellow Cottage Tails, have for the video. Like,
another witness, by the way, who you saw that his methodology was not subject to pre-trial examination. And this would have been really interesting because this is some really weird methodology that he was using to come up with his conclusion. Statements of the defendant to the media, police reports, other people telling me what was found there, and then just rolling over a car at 2 miles an hour, getting consistency and looking at a chart and throwing a dummy who got a head injury. And, that's my opinion and I'm sticking to it.
In the morning, the judge is going to make a ruling about what Welcher can say about contact, apparently.
Well, no, the issue is this. So an expert can't come in and give an opinion on the ultimate issue. And so the analogy that, Alessi was trying to make in the stabbing case was if you had a murder case where someone got stabbed to death, you can't have an expert come in and say, it's my opinion to a reasonable degree of scientific certainty that, he stabbed him. That's basically saying he did it. That's a question for the jury. And what Bob is arguing is that the crime, if you will, here is the impact allegedly between the SUV and the pedestrian. And he's trying to make it sound like that it's my opinion as an expert that the car hit John O'Keefe. And the argument, which is a correct argument, by the way, is that is invading the province of the fact finder. That's too much, as opposed to, I find that the injuries on his arm and on his head and the damage on the car are completely consistent with that and inconsistent with a dog bite, whatever, if that's what he were to say, or inconsistent with whatever. But the way that they're trying to have the witness say it is, she hit him. And you can't do that. That is a question that is literally the issue, first and foremost, for the jury to decide.
Point of the whole trial.
Yeah. So they're trying to narrow what this guy's opinion can be. That's just good lawyering. That's what you're supposed to do.
What do you expect from the judge in the morning? How is she going to rule on that?
I mean, I can tell you what she should do. What she's going to do, she needs to rule that he can't say that there was a strike. That's going to be reversible error in the event of a conviction. You cannot have an expert literally put himself in place of the fact finder and tell the fact finder, this is what happened in my expert opinion. The role of the expert is to provide knowledge that is what lawyers, at least lawyers in New York, call beyond the ken of a juror, which is just lawyer gobbledygook for stuff that you wouldn't expect a reasonable juror to know in the regular course of life. So it's supposed to help the fact finder determine the ultimate question. But what an expert can't do is literally put his own opinion in place of the fact finder and say, I'm telling you, this is what it is, and you should agree with me. Can't do that.
See what happens tomorrow morning.
I think she's actually going to come up with a form of ruling that may shock you in terms of limiting and being very clear what he can say. Now, what Brennan said in response about, well, you know, they said it in an opening that there's no accident. I mean, you got to at least be honest to the argument, okay? Lawyers argue. Now, are you supposed to argue in an opening statement? No, you're supposed to say the evidence will show. But even if it was proper or not, lawyers are going to take what they believe the evidence will show in an opening and what it does show in summation and argue. So obviously, lawyers are going to say there was no car accident, or Brennan in his summation is going to say, you know, there was a car accident.
Yeah.
We're not talking about the lawyers. We're talking
about experts
who juries naturally defer to, telling the jury, trust me, this is what happened.
Exactly.
So his argument was just...
Yeah, that's a weak argument. That is a weak one. You're right.
It's not weak. It's
just not comparable. It's just not the same thing.
Lawyers,
apples and oranges.
Lawyers are always going to say what they think it is, but they're going to say it in absolute. You know, lawyers aren't even allowed to say, I think this. You can't give an unsworn...
Very precise. You have to be very precise.
So obviously in the opening, you know, Alan says, you know, you're going to learn that, you know, there was no car accident, or there was no car accident. That's very different than an expert getting up, like one of the ARCA guys, and looking at the jury and literally saying, it is my my opinion, to a reasonable degree of engineering certainty, which that scientific certainty is really the whatever, that the car is not consistent with striking this, and the condition of John O'Keefe was not consistent with that. I mean, they can't literally look at the jury and say, there's no accident here. They can't say that. So I don't know what he was trying to do. The argument that Bob was making was entirely on point and proper. And, you know, he did give her a case cite. I don't remember what it was, but
first she said there was none, didn't she? And then he gave her one.
No, that was Brennan who said that.
Oh, that was Brennan. Okay. Yeah, it was Brennan. Yeah, you're right.
Threw it out. And actually, if you look closely, I think she knew the case. I think when he started citing it, she was doing one of these.
Okay.
Look, she gets a lot of criticism, you know, for a lot of things. one thing she's not is dumb. She's not dumb. Whatever, I don't know what you think of her. She's not dumb. And there are certain things that you just can't do. And an expert cannot tell a jury what happened on the ultimate issue of fact or give an
So
opinion.
you think she's going to rule with Alessi on this one? It seems like, yeah,
I think
that's
she's
good.
going to make it clear to Brennan,
What the limits are.
where you wrap up examination, that you need to tread real carefully with what he says, because this guy wants to help. Even though he says it's all science, have you noticed he's very
it's very helpful.
I mean, he's willing to put on the hat too.
Yeah.
You know?
Yeah.
So I think she's going to warn him. This is what you can do, and this far and no farther, which is a win for the defense.
It is a win. It will be a win.
Yeah.
Mrs. K is asking, Alessi can't have a quick cross. It has to dissect. Can't trust jury to have brains. Look at last time. And if there is another plant, and where does last plant affidavit stand? Foreman, / Lally.
I don't talk about any of that. The stuff at the end, I don't talk about that.
Yeah.
It's not going to be a quick cross. It's probably going to be the longest cross that he does.
Well, how long do you think it will last? All day?
I don't know, because I really don't know how much do you want to open the door or go through the door that's been opened wide. I can't reiterate this enough. This guy said that I looked at the whole file. I mean, I'm paraphrasing, but everything that was relevant to my opinion. And if the defense wants to do it, this is the way to impeach the clips and tell the jury there's more or whatever. Again, I don't know what those clips are or aren't or what they have. This is the way to get into the Trooper Paul stuff, all the stuff. The time to do it would be through him, because he relied on it. And he repeatedly said that Karen's interviews were a big deal to me. So there is a golden opportunity to, if they have any interest in even fixing that stuff, to do it through this guy.
Ship from Josh H. If John was wearing a hat, how did the spoiler hit him in the eyelid, leaving no bruise and knocking the hat off in the street?
Look, again, there's no science here. It's the problem. I don't know. I don't even know if we determined it was the right height, let alone the hat. And I don't know how we determined, since we were told that the lower light or the lower part sticks out more than the upper light, that if he would have hit his eye and he was wearing a hat, how would he not have been kneecapped and had his legs damaged? I don't understand any of this.
Greg, one from Geevy says, I bet ARCA hasn't watched any interviews.
No, why would they? I mean, again, science. I mean, those guys are going on physics and engineering, there are laws of science, literally, like mathematical laws. And, the guy, Welcher, was trying to use some of that when he was talking about the trigger events and the formula for speed and force. Where the hell was that on the most important issue in the case, which is the vehicle strike? And why wasn't that also a factor for considering the taillight? I mean, how do you, and again, he's not done testifying, so in all fairness, we can't literally say they're done, but do they not have any experiment about the taillight? I mean, he tried, well, let me put it this way. He did a lot of detail in saying why the taillight could not have hit or cracked from John O'Keefe's car. But apparently, pending maybe 20 minutes tomorrow or whatever, didn't do any analysis on whether the taillight broke from striking John O'Keefe in the arm at 24 miles an hour, going back 87 feet, and calculate the force and speed. And I mean, wouldn't that be the most important thing that this guy would be there for? I mean, I just, that can't not happen, right? I mean, he's got to do this.
Mark, have you ever been involved in a case on either side when the lead investigator was not called? And what were the results?
Not from a trial standpoint. I mean, I've seen some post-conviction work where, I've seen cases in the Bronx where at trial where they don't call the cops because they figure a Bronx jury wants nothing to do with the NYPD, so they just pretend they don't exist. But that's not for any real purpose other than we're just afraid the jury is going to, acquit because police bad. In a murder investigation or any serious case, the idea that the lead investigator would not be called is unheard of. And no, I've never seen that. And nor, and again, you can't look at this in isolation. So they call his supervisor and partner, who then dies on the hill of he was not the lead investigator. So it's worse than just not calling Proctor. They really made the whole state police organization look terrible.
From Garrett says, can defense ask prosecution reconstruction expert who he'd hire to do a reconstruction accident, if not his company?
I mean, I don't think you would do that. That's a little, could you? Maybe. I mean, you just wouldn't. I mean, if anything, you might ask, how involved and how big is this community? And, have you ever heard prior to this case of ARCA? Are you aware of them? Are they a competitor? Are they in the same field? They're highly reputable, that kind of thing. But I don't think you'd say like, who would you hire? But you definitely can do it, in the way that I just suggested about, and you saw some of that with Whiffen. They asked him about magnet axiom and how credible it is. And, and they scored some good points there. And of course, it's one of those questions where there's no bad answer. I mean, if Welcher were to say, oh, those guys suck, I mean, that's so ridiculous. So he's going to say, yeah, they're top level guys.
Definitely. Or I don't know them. That might be another answer.
Never heard of them. It
never heard of them.
Not be. I mean, I find that hard to believe. I mean,
yeah.
How many high level accident reconstruction firms can there be? And look, there's a reason why the Justice Department hired ARCA and not Aperture. Okay.
Right.
It is what it is. I mean, they had first pick and they were looking for an agnostic opinion, which, by the way, furthers the argument and the credibility in why they didn't give the ARCA guys too much evidence, because you don't want to color what they're. And remember, those guys are going to say, we didn't even know who Karen Reed is or was at that time. We had no idea about any of this, as opposed to Aperture, who is billing time to watch videos of Karen Reed give interviews and read police reports and things like that. Again, the dichotomy between the way the two of these did it is stunning and really lends itself to thinking outside the box and calling these guys first.
I hope the defense is watching, listening to what you're saying.
Well, that does, they may not agree, though. That even if they're, I mean, whatever. Look, they know,
because there's some advice here. I mean, because I feel like they should be asking, the ARCA guys some questions like, you didn't watch any videos, right? Like, you know what I mean? Like, just
there is
just show the difference between the two, like highlight it.
There are principles of primacy and recency and really driving a point home. And if the Aperture witnesses are the prosecution's, what they perceive as their home run witnesses to win the game, and it's fresh, and the academic fraud is fresh, and the finger painting is fresh,
right,
and all the other kind of weird stuff you heard is fresh, and then you bring in these real professional guys right away, and you look at their demeanor, their credentials, the science that they used, their credibility, the way they did it, you could just crush the prosecution in a day. Hell, you could even break them up if you wanted. You could call one of the ARCA guys first and one of them last. I would do it together, but you could do it. I would use the other scientists at the end because I would finish with that kind of thing too. But I think this is a golden opportunity to just absolutely annihilate them by smothering them with real experts right away. And if you ask me, if the ARCA people are credible and they tell you, I don't care about the taillight, it couldn't, again, I'm paraphrasing. It didn't happen this way, in our opinion. It's not consistent. It is a perfect segue into the whole Proctor issue, whether they call them or not, or however they're going to deal with this, because that means, well, how the hell did those taillight pieces get there? If it didn't get, we don't think they came from a car accident. They got there somehow, and they got there the unnatural way. And to me, that leads into the whole Proctor, Higgins, all those people, the crazy messages that and their text chain, all that stuff. And then you finish with the dog bite experts, the neurologist, the medical examiner, and you're starting strong, you're ending strong, primacy, recency, and at the same time, you're destroying their witnesses. But most importantly, I think if you use ARCA up front as kind of like the fullback to clear the hole for someone else to run through, your argument about planted taillight gets a hell of a lot more plausible in the eyes of the jury, if not even believable. And this happened right after the Proctor glass on the bumper. There is an opening here to really hammer home how bad the last prosecution witnesses were and how they really have no case here with given the burden of proof.
This one here, I just lost it. Jesselyn says, question about asking about billing for the new reports. Jocelyn has that one. What is that?
I absolutely would ask this is a big difference. So this is important. You know what Brennan's trying to argue about the ARCA people, if he's really serious about it, which I don't even know that he is. I think it was all part of the stunt to try to get them excluded, but how biased they are and whatnot. And they got $20,000 after the trial or whatever it was. You could ask Welcher very simple. When'd you get hired? And he'll say whatever. And how did you come into contact with them? And he'll say, I would bet you anything. Tully reached out, right? Okay. And did you go over, billing time, and tell me how do you bill time? And, again, he's a senior vice president. This is not Burgess. He's going to be like, I don't know. This is the guy. What rate did you charge? What rate did Burgess? Is it hourly? And then you could even talk about, how do you bill? Okay. Do you get a retainer and bill off it and then say we need more? Or do you have a blank check? There's no way they have a blank check. And there's a reason for this. So the argument becomes, after you finish a report and submit it, and the case, for lack of a better term, from the expert's vantage point goes quiet, if you will, do you just on your own, without telling the DA, do more billable work? And there's no way Welcher's going to say yes. You know why? Because other clients are going to be watching and they're never going to work again. So forget this case. There's no way that Welcher is going to say, we just do what we want and then send you bills and you pay it. And my point is, Burgess claims he did this on his own. He just one day decided to change, I wanted to relook at it.
Yeah.
And you should say, did you submit a bill for that time? How much? What are the entries? I'd want to see it. At what point was Brennan told? More importantly, Burgess would never do that without checking with like a senior partner. It's not so different from law firms. And what I mean is the person he would have called if he wanted to do new work and was concerned about doing it and billing and all that would be Welcher, because that's who he's working with as like the senior guy on the case. So you could have a field day with that. And I would absolutely ask, how much did you get? Absolutely.
That'd be wild, considering all the stuff that Brennan tried to do on ARCA.
There's something else that happened today. The impression was given that they testify for anyone and everyone who's willing to hire them: plaintiffs, defendants, prosecutors, public defenders. He didn't say criminal defense lawyers. He said public defenders. So there's really two things there. Why did he use that very specific term? Obviously, if you get public funds to get retained, you get a fraction of your fees. Taxpayers aren't paying their bills, not to that level.
Not top dollar.
So when he said public defenders, the implication was we don't really work for criminal defendants. Now, why is that? That could be for two reasons. One, it could be we don't have the reputation when there's people that can waive money and hire anyone, and like they want the best if they're going to pay the best, and that's not us. Another reason is we generally testify for prosecutors much, much more than defendants. And so all this is fair game.
Wow. What if that's a good point. Like, what if all of their business is coming from prosecutors and public defenders? What if 95% of their business comes that way?
Well, they
that
wouldn't
should be brought up. Could they bring that up?
I mean, absolutely. I mean, if they're basically prosecution witnesses, or they work for plaintiffs or defendants on the civil side, I mean, you absolutely can suggest that they're hired guns, if that's appropriate. Now they can say whatever they want. I'd want to know if the rates that they and the fees that they acquired in this case, are they in the normal range that they usually get, or are they bilking the DA? I don't know. Are you,
like Brennan is, Brennan is.
Well, they went out and bought a car.
Yeah.
They went out and bought a Lexus for what?
I know, that's insane.
They, they're in California, they're in Texas, they're all over the place. They don't send files in the mail. They send Tully as an errand boy, which cost a lot of money. I mean, God knows what the fees and expenses are. And I'd want to know, if for no other reason, to make it clear that the ARCA guys, the jury's going to be focused on $20,000 for expenses after the trial. You also have to ask them that when you got hired, you knew it was going to be the DA. You didn't give them a discounted rate. You wanted this engagement, and you wanted to do the work, and you wanted to keep them happy, as opposed to the ARCA guys, right? They get hired with a blindfold on, and they're like, just tell us what you see here. These guys were hired. Now, Brennan introduced evidence that, we didn't ask you to do anything, but, if you want to make money, what do? The argument.
What's in what's in your best interest.
You do what you do, and then you testify because you're billing for that, and you do this, and, there's more work and, future engagements. So this is an opportunity for them to expose these guys as more classic hired guns and basically deflate and kneecap Brennan when he tries to get all his righteous indignation on the scummy ARCA guys, which of course I'm kidding. So, you put that in the mind of the jury now on what a real hired gun expert is, with a bias, as opposed to people who are hired blind with no knowledge of even who you were. And then you only have them testify because, lo and behold, they're exculpatory.
Says Green Enough wants to know, would you call in Trooper Paul? Bring up the state's changing story.
No, I would cross-examine this guy
Destroy him on it.
craziness. And I mean, look, all you need to do is make sure the jury understands that Welcher is Act Two. Okay. This is not their first try at this. So, and Paul had different key cycles for trigger events, right?
Yes,
He had
totally different.
other different analysis. He was working on the assumption of an accident at 12:45. And I think it's very important to make sure the jury knows that these people are willing to change stories and witnesses to fit what they want. And that is a beautiful fact to put out there when the jury's about to learn that Burgess and Welcher both mid-trial changed facts to help the DA, just like they did when Trooper Paul wouldn't work anymore. So I think it's very important to try to establish that, to get this theme that there's no intellectual integrity in terms of proving a case. They're trying to, they have a conclusion and they're working backwards, and they're really jamming square pegs in round holes. That would be the argument.
Definitely have to go on the changing timeline between the two trials. That is such a big part of this.
Timeline is changed twice. It changed from the first trial to the second trial, and then it literally changed in the middle of the trial.
Yeah. It's like Half-Lives now. Keeps changing it. Now they'll change like halfway through the prosecution, the defense. Again. I don't know if they can change it again, but I don't know. Here's a comment. So Bev is just now getting to see ARCA updated report. Is this troublesome?
No, she said she hasn't seen it or doesn't have it, but that doesn't mean they didn't give it to the DA. No, I don't. No, she just hasn't seen it for whatever reason. It doesn't matter.
Going back to earlier today, North Shore 86 says, Mark, any thoughts on why he kept referring to the documentary clips and the influence that has on the jury?
It's weird. The cynic in me suggests that, obviously this prosecutor wants to draw as much attention to the clips, which he believes are powerful. And could he be trying to bootstrap the credibility of the clips by having his scientific experts say those are important? So could this be an underhanded way of attempting to boost the credibility and influence on the jury the clips have? I'm a cynic, but that's probably what it is, because it makes no sense scientifically for this expert to clown himself by saying that Karen's interviews had any impact on what he did. And he said it multiple times. And I believe when he was asked his final opinion, what led to it, it was the first thing he mentioned. So I think that is just a cynical way to tag for the jury in the eyes of the prosecution. Those clips matter because the expert says so too.
Mazza in the chat. He might be jumping up for a second tonight to say hi. What's up, Mazza? This question's a good one. Jocelyn's had some good questions tonight. She said, would you even address the collision between John O'Keefe and Karen Reed's car in the driveway, given how convoluted the data was?
I mean, look, you'll have to wait and see what the ARCA guys say. They know, obviously. You can't just ignore it. There was an impact between the two vehicles, and there is an issue of some degree of damage to the taillight. Now, if you don't address what happened in the driveway, the question is, how did the taillight get some form of minor damage? I don't know what the answer to that would be. It doesn't mean if there's no accident from the experts, meaning the ARCA experts, that it proves guilty on a reasonable doubt. But I don't think the defense is going to literally ignore and yield ground by not even trying to contradict or present whatever evidence they have to talk about how the taillight got cracked. I mean, let's be honest. I don't know how credible the analysis was, from Welcher on this point, but it was a hell of a lot better than the impact between the pedestrian and the SUV. I mean, that made more sense than what he ended up with when we literally were talking about, putting paint on your arm and doing fake accidents and all that stuff. So, yeah, I think they're going to have to deal with it somehow.
Considering that we're hearing there's a younger jury, do you think Wolf would play well, the ARCA,
I
the
think
ARCA bros?
with the women, yeah. I mean,
Yeah.
look, he's a successful, very successful PhD at this place. Good looking guy, charismatic, presents well, polite. Yeah, I mean, I think, it's one of those classic, like, women want to date him and men want to be him kind of guy. So, yeah, no, I think they both project really well, really earnest, really professional, really skilled. I mean, to me, they are, in terms of demeanor and what we've seen in terms of analysis from both over the past couple of years. I mean, I think there's a reason why the defense is confident with ARCA, and there's a reason why you see now why Brennan has been so desperate to try to get rid of ARCA.
Everyone wants this question always comes up, but this is uniquely phrased, and I think it's probably up to the judge, but we'll ask the question. They went with separate law enforcement agency when discussing feds with Jen McCabe and others. Can they go with that explanation about who hired ARCA?
It's like you answered it, whatever the judge says. She's going to say no. She's going to say a third party completely unaffiliated with the defense. I mean, look, obviously Justice Department would be the best, but as long as the jury knows that it is 1,000% nothing to do with the defense in any capacity, it's a win.
To win. I just hope they figure it out this time. It would be great if someone on that jury was just like, "Hey, that must be the FBI." Like that would be.
Well, the reality.
You never know. You never know. It could happen.
The FBI has been mentioned in this case.
Right.
The first trial has been mentioned. I mean, I think we're being silly at this point. People know that that Jen McCabe lied to the FBI.
Yeah, that was interesting. That didn't come up in the first trial. That's a new thing. Yeah.
Yeah, we ought to really just cut through the bullshit and just, it is what it is. And if it opens the door and Brennan wants to say, "Oh, nothing came of that investigation," whatever. I mean, that's a trade I would make if I were the defense. But the judge appears not to be willing to allow that.
This is another common question that kind of comes up about Abacus Flinch says, does it seem like Hank is not spending time on this case because he knows the verdict is already in? Commonwealth has a ringer on the jury. Oh, this is a little different, actually. A little different than I thought.
No,
what do you think?
I think he spends a lot of time on the case. I think he's made some decisions that I don't understand, and maybe some other lawyers don't understand or agree with. But I don't think, whatever you think of him, that a fair criticism would be doesn't work hard. I think he does, and he appears to have spent a lot of time on this. Again, I can't, he does a lot of things I don't like, but I don't think he's not spending time. I don't think he's mailing it in. I don't think he's lazy. I certainly hope he doesn't have a ringer on the jury. That would be inappropriate. No, I think he just has the losing hand. And, that's how trials are. That happens, somebody
you could be the best chef in the world, but if you got literally chicken shit, like you're right. Like if that's your ingredient.
Yeah. I mean, look, he's a good lawyer. He is, even though he does things I don't like. The problem is he's outgunned. I mean, the defense team is better. And it's they have a deep bench, as they say, where he's just, on his own, and over the wear and tear of an investigation and trial, in a case like this, you need help, and he doesn't have it. and the defense does, and that's a huge, huge advantage. Last time, you for all intents and purposes, you had two people breaking up all of this stuff, including all the experts, where this time you have one guy whose sole job essentially is all of these really dense experts, and he just happens to be like wired for that. I mean, that's who he is. He's the best at it. And that frees up the other lawyers for some of the other types of witnesses and arguments, summation and whatever, to not have to spend so much mental bandwidth on all the experts on top of that. I mean, that's a huge advantage that the defense has and Brennan doesn't.
A few more questions came in. It's a good one here. Bev's bias beratements and ruling says, how hard does Mark think Brennan will go at ARCA about the nonsense that they were communicating with the defense? Bev's grave concern moment.
So you've probably heard me say this before. I think it's all bullshit. I think it was all a stunt, a gimmick, no jury, and it was designed to get a remedy of trying to get them either kicked out or excluded or limited. I can't accept the fact that he literally believes it will be effective cross-examination of those guys to imply that they are biased, whether they're friends with the defense, getting a little money or deleting messages, which would open the door to why those messages were deleted. I think it was all a pretrial stunt of nonsense. Now, maybe he'll do it. I think that's crazy, but I don't think he will.
Shirt, is that the black dog? Or is that a different shirt?
Ah, that's the black dog on Martha's Vineyard. Yeah.
Oh. Was it that's not the place that Spacey was at, right? That's a different one. I get him confused.
Probably. I mean, look, the place, it was,
was it the black dog? I don't even know. I have no idea.
We used to go every year, and the first time, we had a black lab and growing up, and they came
home black labs
shirt, and so we would go, and then it got made trendy when a certain guy became president.
Was it Clinton? Was it Clinton or Obama? Clinton.
No,
Clinton.
Yeah.
Clinton was hanging out there. Yeah. Yeah, that's I love black labs. The best dogs ever. I walked one twice today. He's the best. He's such a good dog. I take my dog to walk with him, the customer dog.
No, labs are the best.
Yeah. They love people. They like other dogs. Just all fun.
Yeah.
It's a good question from uncharted territory for a lot of us. Meavy says, do you think Brennan will do well on cross with the defense experts?
No. I mean, you've kind of seen a preview of it. I mean, he's better than most, but the disadvantage he has is he doesn't have a science mind. Now, he's pretty good as far as lawyers go with experts, because usually an expert thinks they can just talk over the lawyer and you can't compete on the subject matter. No matter how good of a lawyer you are, there comes a point where they can talk over you. That's what makes Bob scary, is he actually understands as well as the expert on a lot of this stuff. So he can kind of go toe to toe and do it in his forum, which is a courtroom. So he can't get talked down on substance. I think Brennan can't hold that. He tried that with Russell. He got pushed down. He tried it to some extent with the ARCA guys. He got pushed down. If he's going to scream and yell and act like a tough guy, no. I mean, I don't think it's going to get him anywhere. I mean, he can cross-examine. He can try to suggest this. He can try to suggest that. But if you've seen, Dr. Russell and you've seen the ARCA guys, they hold their own, and they've gotten a preview of the way he is. So no, I think they're going to be fine, and I think it's a problem for the prosecution. They're good experts.
782 says the crash test dummy landing on its back during Jen McCabe's 911 call. She tells the dispatcher that Carrie Roberts and Karen are turning him over. Looks like he did not listen to the 911 call.
I mean, you could point that out and you could ask him, did you hear it? You relied on so much. Are you aware of this? Would that change your opinion? I mean, you could just go crazy with this guy and throw all this stuff at him because he said I relied on all this.
I'm looking forward to tomorrow. Tomorrow's should be fun.
That'll be a fascinating cross for sure.
Just gonna have to deal with, I don't know. I'm guessing maybe like a half hour of Brennan, but who knows when it gets started? That's the problem.
Yeah.
It'll probably start at like 11, even though she said it will start at 10.
One day after a 6-day break.
Yeah. What do you think about like how court is being run? Like today, they brought in all these new, I don't even know whatever you call them, slides or whatever. She's always like, you gotta have everything in early, but nothing ever is. Like it's like today there was more new stuff coming in. There was like a delay on that. Does it seem like she really doesn't have control of what's going on in the courtroom, or is it just me?
No, I don't think she doesn't have control. I just think she runs a very loosey-goosey schedule that starts late and ends early. A 6-day break in the middle of a murder trial is unheard of. Now, look, Memorial Day, you're going to have 3 or 4 days. There's no way around that. But a 6-day break followed by you bring in the jury today at like 10:30, 11 or whatever it was. And with all the other breaks and other stuff, they really only heard a couple hours, 2, 3, 4
Ridiculous.
hours. And then you come back and you say, oh, by the way, we're starting an hour late tomorrow. I mean, it's
half day on Thursday.
Don't forget stuff. I mean, over 6 days, you forget nuance. So, yeah, I mean, it's a strange way to do it, but that's how she did it last time too. I mean, we know how she does it. I mean, there's a half day Thursday, late tomorrow.
Yeah.
I mean, it would worry me if you're the defense a little bit because nuance in facts favors you. I mean, with all these inconsistencies and people forget stuff. That's
what I get worried about. This is what I feel like happened last time too.
Yep.
They threw so much at him. We got our friend here. We're having another little reunion tonight. What's up, Maz? The 3Ms.
What's going on?
How are you?
3Ms are back, gentlemen. How are you guys doing?
Great. How you doing tonight?
Doing very good tonight. I'm very happy. Very happy to be back on this show. I think the defense is dominating twice as much, maybe 10 times more than it did last time. And it's just been, I think this trial is really just starting to get hot right now. I think that the best is yet to come from the defense. I thought that the first half of the last year's trial was the most notable half. I think this time around, I think Hank Brennan's already getting ready to play people that are already on his own witness list as now being called by the defense, and he's going to try to cross them instead. I think that's probably what he's going to end up going for because he avoided a lot of people that typically were called by Adam Lally last time. And I think he's kind of already anticipating they're going to be called by the defense. And I think he's playing this from behind. That's just my opinion, or to some degree hoping that they won't be called at all. For me, this was I caught up a lot of this stuff, obviously, at lunch or after work today. But for me, this was a bittersweet day for me, who's been talking a lot on this show a lot, my own show, other shows a lot about how far the arm would have been hit and how far it would have been gone. So fortunately, there was a member of Aperture, Dr. Judson Welcher, who was there today, and I wrote a nice little write-up about him on my X page, which is basically he gave me what I always wanted to see, which is basically proving that the defense is right. It actually proved how outrageous getting hit by a vehicle would have been, because if 2 miles per hour driving in reverse can knock an arm out of the way, which was very clear, when his own arm was hit or whomever was standing there's arm was hit, he not only got his arm not only moved, but he started taking steps away as well. And this is just off 2 miles per hour, let alone any other mile per hour higher than that. 3 miles, 24 miles, whatever you want to call it, would knock the arm out of the way even further, not only even further, but only even faster. So basically what I'm saying is is if that arm's already flailing back like it was in that video they played in court today, as quickly as it was off 2 miles an hour and off the distance's arm, and body moved, then guess what? What's 24 miles an hour going to do? It's going to be even faster, even quicker. The arm's going to go even further. And it's going to be, to that vehicle, like it got hit by a little pebble. That's how quick it's going to happen. It's not going to have any impact on the tail light. And this is something I've been arguing, like many people, for months, is that this is absolutely ridiculous because the taillight isn't hitting an object that is giving it enough resistance to cause it to shatter. So when Karen Reed backs up in John O'Keefe's parking lot and the vehicle makes contact and that causes a crack, that's reasonable because it's backing into another vehicle that has a level of weight and resistance to it. When it's hitting someone's arm who's standing there, you see the guy in the video today, 2 miles per hour was enough to knock his arm back and make him want to take steps away. Immediately, 24 miles an hour is like getting hit by a gigantic fan, like Twister, like the guy got sucked into the Twister at the beginning of the movie in the 90s. There's a movie reference for you. But it's just like that. It'd be so quick, it'd be like to the driver, if there was a driver, which there was not, Karen didn't do it, it'd be like a pebble pea stone hit the vehicle. It's ridiculous, and it would not cause the taillight to even crack. And if it did, it would no more than crack. But that crack is obviously coming from One Meadow Lane, where that vehicle, that taillight, made contact. This whole thing is manufactured. It's a total farce. It's a total fraud. And today, the prosecution had a witness that, for me, and maybe many others out there, proved a theory I've been talking about for a long, long time, that this wouldn't have happened. She would have had to have hit a large object that would have resistance. But again, 2 miles per hour was enough to knock that guy's arm back and enough to make him take steps away to walk away from it. And not only that, but his shoulder was hit. Now, when he has the blue ink all over him in that video reenactment today, guess what? That blue ink does not match up the length of the arm as much as the wounds on the arm do. Now, they tried to do their best Blue Man Group impression today in that video. They did. They tried. They really tried. But they didn't really convey any kind of, and they had it side by side. Here's my arm in blue. Here's John O'Keefe's wounds. It doesn't go further enough. There's a wound on John's just by his wrist. There's no blue coloring by his wrist at all. There's none of that. It's a total farce. And additionally, this proves all this does is prove to a jury that how ridiculous this really is. And furthermore, there was a test done that was placed on TikTok, I believe, where they actually reenacted it. His wrist would have been broken. His elbow would have been broken. But when they actually do this reenactment that you saw today in court with the blue ink and all that, the man's shoulder is getting hit. The man's shoulder is getting hit. He's almost getting broadsided right in his shoulder. There would have been a shoulder injury. There would have been maybe shoulder bruising. There might have been a dislocated shoulder if that vehicle is driving 24 miles an hour. It does not make sense. This is an absolute farce without question. And that's all there is to it. And today, I mean, honestly, obviously the defense needs to cross-examine. But for me, looking at this, I'm like, I'm picking it apart. I'm like, this is so obviously something that never happened. The only thing that is realistic is that John O'Keefe went in the house. He was attacked by a dog, perhaps one or more other individuals, and his body was left to die in the cold. And that's what I take away from what I watched this evening.
You got the Blue Man Group in there.
I had to.
Blue Man Group was hilarious. I
had to.
When you got a Blue Man Group in there.
The problem they're going to have is beyond the medical testimony, which is interesting because the DA has offered none to talk about what damage you'd expect from an arm and things of that nature. Jurors are allowed to keep common sense. And obviously medical experts get a high degree of deference and you listen to them. But there are certain things that common sense tells you, even if you don't have any medical training, and if you don't think there's going to be people in the 12 that deliberate that aren't going to have a little common sense on the point, which is, I don't care what any of them say, okay? If the guy's arm is sticking out and is getting smashed into as we said, a car going at 12 times the rate of force from the 2 miles an hour at 24 miles an hour, okay? A 6,000, 7,000 pound vehicle on a hard polycarbonate taillight that basically exploded, okay? 47 pieces all over the place. and that guy is not going to have a bruise or have mush in his arm, the bones just shattered like the taillight. Medical testimony or not, there are going to be people in the jury room who are going to say, no way. There's just no way. And that's their whole theory. You saw it today. I mean, this is kind of an important point. It's only today that you actually saw their actual theory of the impact, of which they said, we don't know how it happened, but here's the test I'm going to do. I'm going to walk around with my arm out and have a car back into me, then roll over it and do that. Okay. So that's their story and they're sticking to it. I mean, there is a video of their theory of how the accident happened. And if you were to say, put that at 24 miles an hour, also not from a couple of feet, 87 feet. That's why his testing, that's why his little experiment is just bullshit. It's not germane to the issue. Okay, if you want to do a test, you need to show a car go up 30 feet, put it in reverse, and then back up 87, gaining momentum. And at that impact, hit it and see what happens. Yep. Now, nobody's going to volunteer to do that, obviously, or should they?
Right.
So too in the snow and at night, and it's just,
I'm telling you, that experiment it's a joke. It doesn't correlate with what happened and what they claim happened and what they claim they know or don't know what happened. So it has no value to there should have been a Daubert hearing, and you could really make an argument that this guy's methodology, which again is reading the file and doing this little cheesy experiment, is not scientifically proper. It's not accepted. It's not peer review. You could go on and on and on and say, this is not how people do this. Okay. No. But a jury, one of them, probably 12 of them, are going to say, how is this guy's arm cut up like that, but not bruised, not broken bones, and a taillight made of materials that they use for safety goggles, for safety windshields on airplanes and things like that, shattered all over the place.
Yep. His arm would have more likely been bruised than cut, scraped, and bleeding. And if he was bleeding, it would have been almost like a blood inside the skin type of, almost like a bloody bruise inside the skin. It would have been like that. It would be like red marks and whiplash marks
swelling
all over the place. Yeah. Oh, it would have definitely been like that. Yeah. No question at all. And that would have been far more realistic. If someone get hit by a vehicle in reverse, they're going to be bruised. They're going to have broken bones. It's going to be maybe even shattered bones to some degree. Again, 2 miles an hour in reverse. And that guy in this video his arm's already moving away. I bet you if you sped the thing up, that video up, it'd make the impact look even crazier. It makes no sense. And before a jury, how can they even buy it at all? It's absolutely insane. It's unreal.
You both, how likely is there this, and Angel's asking mistrial. I'm saying a hung jury. How likely do you think there will be a hung jury?
I don't think so. But I mean, I think in the worst case scenario, you're probably looking at a hung jury. I never thought I would have said this, but I think that in many ways, this is playing out worse for them than it did the first time, the prosecution. I mean, obviously, I understand they're claiming that the trigger event science shows this and that shows that, and I get it. But there is a clunkiness to the way they have presented their case, and their witnesses are all just getting tattooed on cross-examination, where I think you poke so many holes, you're dealing with a reasonable doubt. And I think, you know what? When you give really skilled lawyers a second chance, okay, to kind of reevaluate strategically, how are we arguing and selling this? I think reasonable doubt is a much more important concept in giving the impression of what might have happened here. And they go hand in hand. You can do it effectively, but for whatever reason, they might have leaned in a little too far towards proving, even though they had no burden to, that, it couldn't have been her because it was them. as opposed to it ain't her. There's no accident. That taillight, don't look at me. Look at Proctor. He's the one who got fired. Those text messages, that makes no sense. I mean, what are we doing here? Look at their witnesses. They're experts. One of them lies on his resume. The other one is his boss and is going to claim he didn't know and is playing with finger paint instead of doing scientific experiments. I mean, you go on and you say that's reasonable doubt. I mean, it's everywhere here.
Yep. There's more reasonable doubt than sprinkled taillight.
What do you think about the hung jury? Do you think what do you think about the possibilities of that, Mazza?
I think I'll say this: it's all in play. I don't honestly, truth be told, until Karen Reed's considered called not guilty or declared not guilty on all 3 charges, I am absolutely anticipating a mistrial or a hung jury or something like that. And it's one of those things where it's like the Red Sox winning the World Series for the first time. You're so used to certain things happening that until it actually happens, you're not going to believe it. And after what I saw take place in that courtroom last summer, until the moment I hear she is acquitted of all 3 charges, I am sitting here with a constant state of vigilant alertness, anticipating that something's going to happen and a fix is going to be. And I personally, in my mind and heart, truly believe Karen Reed is going to walk out of there not guilty in a couple of weeks. But I if it all this happens again and they push for a 3rd trial and they do pursue a 3rd trial, I wouldn't be shocked at all. But I think, to Mark Bederow's point moments ago, I don't foresee Karen Reed being declared guilty on any charges. And if she is, I have very serious questions to ask about how they reached that verdict. But I don't expect Karen Reed to be declared guilty or go to jail. But again, I am right now, I'm very much on edge for a hung jury or a mistrial to be declared. But like I said, in my mind and heart, I think she's going to be acquitted. So
excellent. HH asked a question: should AJ give a mini lesson on the standards to the jury in the beginning of closing? And I also want to throw in a little add-on. Apparently, it's a 1-hour closing for each side, which is that's rough. I mean, you want to comment on the question and then even about the 1-hour closing, the limits of that, and the way it should be, Mark?
Yeah, the answer to the question is no. The answer is you should be talking about reasonable doubt every 20 seconds. And you stack this fact alone. That's why you start with ARCA. That's reasonable doubt. You add this to ARCA. That's more. You just drive it home, those words again and again and again. And you have to talk to the jurors like they're 5 and make it clear what reasonable doubt is. But it's not something I would just mention in passing. That's the standard. You have to marshal each fact on top of the next. But that's why ARCA has always been the key, because that alone is reasonable doubt. If that's credible evidence, it's over. Never mind the first trial, the juror. It is what it is. Okay, it's a different jury. I don't put any stock. They're different people. Who knows why some of them thought like that? I don't know. But the point is, there's so much more than the ARCA stuff, and it goes on and on and on, and you leave them with no choice. And by doing that, you also are brainwashing them, because they're going to talk about that in the jury room, and they're going to say, well, there's this and this and this and this and this, and all we need is a little doubt. And if you process that logically, I don't know how you get to any other place. And they're going to have to obviously emphasize that reasonable doubt, what it means, but how it applies to the certain facts.
Yeah, it's a great question. I agree. I think that reasonable doubt needs to be established in that closing argument. Every couple minutes, even reasonable doubt. It should be the whole theme of the closing argument, because we learn from Ronnie the juror. A lot of people have unfavorable opinions. I don't shame you for that at all, but definitely that seemed to be something that kind of, when it came to count 2, might have gone over that jury's head. So for sure, definitely talk about reasonable doubt.
Repetition in this context is good. It may sound, in the abstract, oh, that sounds so boring. first of all, look who's doing the summation. It won't be boring. Okay.
Yeah. Right.
That there are skilled orators and there are skilled orators. That's a skilled orator, but repetition of reasonable doubt and these facts is good. It's not boring and it's important. And that's much more important than anything else for style points.
Yep.
We noticed this today. Allison says first voir dire allowed for defense today.
Well, yeah, because they learned that all of a sudden Welcher, as we suspected, we were wondering how this would play out. He did what Burgess did in reliance on that. And they're saying, here we go again. What the hell is going on? And she let him do it. Look, she's not dumb. Okay. She recognizes this is weird. This is not how trials are conducted. And, she let him continue with the Burgess thing. Now it's affecting the other expert. Now it turns out that, he says, I was told to do it by Brennan. It's getting sleazier and sleazier and sleazier. And people can see what's happening here. This is not normal. Nothing about this case has ever been normal. And it keeps happening day after day after day to the point in the middle of trial, they just continue to move the goalposts again and again. And, they've done that with these witnesses. You had the guy at the end of the show, the end of the day, Welcher basically tried to give that ultimate opinion that she caused the accident, which is totally inappropriate. I mean, and by the way, an expert knows that. This guy's testified in court 1,000 times and he's giving answers that he knows can't possibly be proper. So look, they just have to keep plugging away, keep arguing, keep objecting, keep making records, and give them no quarter. That's what you have to do.
Question from Stephanie says, am I the only person who noticed how many times Welcher talked about how long and slowly he worked on his degrees in education, just as Burgess worked 16 years on his fake bachelor's degree?
I did hear that, that he spaced it out. I mean, again, at least he didn't lie about it and finished it and didn't say he was pursuing it. Who knows? But he did a lot of things, which I think where he tried to come off as the everyman and didn't really land for me. I don't know. I mean, I don't think it's the biggest deal in the world, but his kind of like making jokes about why he didn't go to medical school and pissing people off and doing this. And it just struck me as, you're trying too hard. And somebody said it on Twitter and I thought it was really effective. And they said, this expert is selling more than he's telling. And that resonated with me because that was a better articulate way of what, was kind of stirring up in my mind, that this is trying too hard. And this feels like a classic hired gun expert who's trying to be clever and just, I don't think it landed.
Question about Welcher from Victory AK86 says, didn't Welcher do irreparable harm to his own company by making such a demonstration in front of millions of viewers?
Well, that train left the station last week, right? With Burgess.
Yeah, I was going to say, yeah.
I mean, yes. Did he do more irreparable harm to the company by having what appeared to be silly? I mean, those tests at the end with the paint, I mean, it almost was just silly. So, yeah, I think he did a little damage with that. But to me, the bigger damage was I changed my testimony or I changed my opinion in the middle of the case because my other guy changed his opinion, who's the guy who, has been pursuing a degree for 17 years, lied on his resume, did this. Everything's going fine. And then, I've been getting all kinds of emails about this, but I didn't open them up. Well, maybe I opened up a couple. The company looks like They're a not well-run organization. They look like they've got some crisis management that they need to be doing. And when you conduct the autopsy of this case and, you have the winners and losers, right now, I'd say Aperture is the leader in the clubhouse as the number one loser in this whole case, because I think their firm has probably suffered some serious reputational damage. I mean, they look ridiculous with their due diligence just on Burgess and his credentials. And I thought, Welcher didn't come off so great today. I think if it was just Welcher on his own, I don't think he would have looked great, but I don't think you'd be talking about, my God, this company. But I mean, how do you erase from your mind this craziness of last week, which is, the shot, and then the chaser is Welcher finger painting to show a car accident? I mean, it's not a good look.
I mean, yeah, to that point, just like Jessica Hyde, these are the best experts they can find. These are people that necessarily are not always credible, and if they are credible, they're probably the least credible people you can ever find that are willing to actually get on the stand and address these particular issues. And it's just like you said, they go up there, anything they do is a demonstration. It's a farce. Even last year's trial, you had Trooper Paul representing the state police. He struggled up there. Even the prosecution didn't want to call him back to the stand this time around. It's just, that's what they're up against, because they don't have the evidence on their side. They don't have the facts on their side. And when the defense does try to present experts like Dr. Marie Russell and then the ARCA guys, boy, they fight that tooth and nail, don't they? They have to get those guys on there. They fought, kicked, scratched, and clawed to do everything they could to get them prevented from being able to testify. So that's what they're dealt with, because they don't have the facts, and that's how I look at it.
Yeah, no, that's true. They fought like hell to keep out all these defense experts. They did.
Experts, ARCA's Dr. Wolf said in his testimony last time, driving at 24 miles per hour in reverse is nearly impossible. And if you don't believe it, try it. A lot of us have tried to do it. It's hard. It is hard to do.
I don't know if it's impossible, because somebody sent me
nearly. It's just hard to control the vehicle like going there. Yeah.
Somebody sent me forwarded a Twitter comment by one of those wacky trolls, the old lady in Florida who cites God all the time and then wishes for terrible things. That apparently she was claiming that she has a Lexus and she did it, and it can be done. No, it's ridiculous. I mean, look, people who have tried this, whether it's Wolf or others, if you don't think about it, you think 24 miles an hour is not going fast, but when it's in reverse, I mean, you would never do that. So I don't know if it's impossible, but I imagine you would risk losing control of the car because you're not used to doing it. Now you're doing it in slippery, snowy, or at least the beginning of snowy weather. Obviously the car went 24 miles an hour in reverse at some point. There's no dispute there, but I don't think it's the kind of thing that somebody in front of a house, without corroboration. I mean, you could argue whatever you want, but their problem is they have no real corroboration. Nobody sees anything. You're talking about advancing the car 30 feet, putting it in reverse, and just gunning it backwards for 87 feet. And that's quite a distance. And it's actually more than 87, because that's just the triggering event. It has to go on for longer. So
Stopping part of it.
It's a tough sell. Look, the street there, it's been said in front of Fairview, it's not entirely straight. You would go over that soft curb. Unless you're all over the place, it seems hard without corroboration to believe that.
Right. I mean, I've tried it before. I did it, fall of 2023. I tried it in a large abandoned parking lot that was very wide, very deep, did it. By the time I got up to 20 miles an hour, I was already thinking, whoa, I need to hit the brakes here and slow this thing down. And that's exactly what I did. Now, that's a different terrain. No snow, right? Like we talked about. No curb and no curve in the road. And also, like you said earlier on the show, no vehicles in the area, no Higgins vehicle, none of that. It's a whole different terrain. And for all this to happen, there's no chance, because quite honestly, it didn't happen.
A question: is degree of engineering certainty the same as scientific certainty? 95 confidence interval. I don't know about any of that. Do you?
I wouldn't put percentages on it. I mean, usually you would say to a degree of scientific certainty. I mean, we all know what he meant by engineering because some of it's engineering, but some of it's not engineering. I mean, there could be some of that on cross-examination. Was looking at Karen Reed's interviews part of your engineering analysis? Was looking at videos or photos of taillight that the state police said were recovered on the ground? Is that part of your engineering? I mean, you could have a lot of fun on cross with this. I mean, I don't even know technically what they mean because he didn't seem to do a lot of engineering work. He seemed to do just kind of like data analysis, like a guy at a computer looking at things. It was just like a data analyst and says, this is what I think. I don't know where his engineering and biomechanics skills serve the purpose today based on what he was concluding, as opposed to the ARCA guys who are going to talk about physics and force and blasting and speed and all that stuff.
Yeah.
That's science. This didn't feel like a hell of a lot of science today, as much as an analysis of data after being biased and influenced by a case file and people who wanted me to reach a conclusion and were paying me a lot of money to do that. That's the argument I'd be making about these guys.
Yeah.
Does you want to add anything else on that, or
I'm just praying that the jury can see all this, and they can clearly see all this, how obvious this is, how ridiculous this theory is by the Commonwealth of backing up your vehicle. Even to pull that off of it in itself is unrealistic. Even for her to back up and shatter taillight on an arm when at 2 miles per hour that was shown today, it moves the arm out of place. And additionally, that taillight, it's not armed to the teeth with knives and razor blades and sharp objects that are going to cut the arm on impact. At 2 miles an hour, sent the arm out of the way. It's preposterous, and hopefully the jury sees that. They need to see that. And it's like I said, the Commonwealth is doing everything they can to put any expert on the stand they could possibly get to make a case. And hopefully, like we're all sitting here saying to ourselves, this is not sticking. They're doing a poor job. They're losing. The defense is dominating. The jury needs to see that, and I hope they are.
Excellent. I guess final thoughts tonight. Anything else that we didn't cover that you want to bring up? Go to Attorney Bederow.
No, I mean, it's just fascinating to me that the way the prosecution broke the case down into phases. They started out with, I hit him, trying to show that she made admissions. They then kind of moved into the intoxication evidence, so they alleged, and then they kind of moved it into the science from the medical examiner, and we're going to show you that this is what happened to him. And what ought to have been by far the strongest evidence, if they're going to win, has been their worst. I mean, you could go back several witnesses to this last phase and you say, what are they doing here? I mean, the medical examiner was a complete disaster for them. Obviously, the first Aperture witness was terrible for them, at least as it relates to his general credibility. You can quibble all you want over whether his corrected data is right. I mean, Welcher was not a smooth operation today. The other expert they had, I think her name was Hanley, gave the defense a lot of important evidence over the glass that didn't match John O'Keefe, that had to have, only matched what Proctor claimed he found weeks later. That doesn't make any sense. People are complaining about that. Well, it was only physically tested. They never did any microscopic testing. And you sit there and you say, well, who has the burden of proof here? What is this? And that's why when these people online tell you about this, you should ignore them. It's the responsibility of the prosecutor to prove, not the defense. And the only evidence is it doesn't match. That's a you problem, not a me problem. So that witness was clunky. Dr. Wolf, the neurologist, I think wasn't much for them, because at the end of the day, he said people walk around where I'm from drunk all the time and they look like that. That's not so great when you have the burden of proof. He acknowledged that these injuries above the eye could not have come from smashing his head on the ground, which I think most people recognize logically means, well, there had to be more trauma to him from something else. So that means there's got to be something else going on here, whatever that is. And, Welcher still hasn't been cross-examined. You still haven't heard from the ARCA people. You haven't heard from their medical examiner, Dr. Russell, the other dog person. So I'm just pretty surprised at how clunky the very end of the prosecution case has been. How it's kind of been just a big dud at the end. That's surprising to me. Not that I expected them to win, but I didn't expect their witnesses to get sliced and diced like on key points that they are. And again, not in Perry Mason style. That never happens. Well, Burgess was close to it. That's about as close to Perry Mason you'll actually see. But when this comes back for summation and the evidence is marshaled, there's a lot of damage done. And you forget a lot of these facts. I mean, you have a medical examiner who said, I can't even differentiate between accident and homicide. I mean, how the hell is that not one of these points of reasonable doubt to stack on top of each other? So I'm just surprised at how unimpressive the very end of their case has been the last week and a half or so.
God. Tracy had a question for you. This has been coming up a lot tonight. Tracy wants to know, have you ever seen a directed verdict? Does this case reach that level that a normal judge would at least dismiss the charge that requires intent?
So directed verdicts or trial orders of dismissal, I mean, you have to look at it in the light most favorable to the prosecution. It just has to be, meeting a prima facie case that a reasonable juror could find, blah, blah, blah. So they're extraordinarily rare. I've seen counts dismissed before, not often. She's not going to dismiss the murder count based on the intent issue. To be honest, I don't think there's much evidence of intent. The best evidence they probably offered was today when he said she moved up 30 feet before slamming it in reverse, and that doesn't impress me. But given on what we're dealing with, that's as good as any other theory of intent, I guess. The problem really is they haven't proven a car accident, really. Even with Welcher, I mean, you could argue from a prima facie case, with his opinion, they did. They haven't proven a cause of death or manner of death. I mean, this is a problem. And, just because the car went in reverse, I don't see very impressive evidence, medical evidence that caused his death. I mean, they have like a basic causation problem. And the medical examiner did not give them that, which is unheard of. I mean, it's your case. It's your ME. It's your witness who did the autopsy. And she's basically telling you, I don't know, maybe, but doesn't look like a car accident. I don't think that Welcher got them there with causation just because he offered a, half-assed conclusion that, it seems to fit because there's paint on his elbow and the crash test dummy head, and that's what it looks like to me. But do I think she's going to dismiss it? No. But I would tell you, most of those motions are very pro forma and very just, whatever. I'll rely on the record, which is code word for, I know, whatever. This is a real motion. I mean, they could make it and argue and get her to think. She's not going to do anything, but so I think judges would think about it, ponder it. I don't think they would ultimately do it, but there's issues here. And if you're thinking about it in the context of a trial order dismissal as being a plausible motion to even make, that's not good when you have the burden of proof beyond a reasonable doubt, which is a hell of a lot stronger than a trial order dismissal.
Any final thoughts tonight?
I do.
We didn't bring up.
I'll just say this. I think it's great as just I want everyone to think about how great of a job they think the defense is doing right now and multiply that by about 100, because I think when they start to do their direct examinations, I think it's going to be extremely methodical. I think it's going to be the prosecution and Commonwealth's worst nightmare. And I think you're going to see the defense, however good you've seen them so far, it's bigger, badder than you've ever seen before, and the best is yet to come. I'm expecting nothing short of greatness, and ultimately they're always great. Let's be honest. This is a super team here. Robert Alessi so far through this whole thing has been tremendous. Just the way he's slicing and dicing on cross-examination has been absolutely masterful. It's been an honor to watch, quite honestly. And the guys saw his high school photo that was on Twitter yesterday. It was a pretty awesome photo, the way his hair used to look, all that. But Alessi's the man. He's awesome. He's really fired up. He does a great job. Like Mark said, he knows all the technical jargon. He can go word for word with anybody and really beat them at their own particular game. And it's a methodical approach. And this is going to be an explosive second half of the trial coming up. I can kind of just feel it this week. There's a renewed energy in this trial. It's kind of a little bit low key last week, but this week, get ready for it, because the defense is they're about to ratchet it up to about 120 miles an hour, maybe even more than that. But it's going to be awesome. I'm ready. I'm really fired up. I cannot wait. And like I said, I think I'm expecting a very methodical order in which they call these witnesses. And to Mark's point about the prosecution, I think it's been very lackluster. It's been very purposeless. What's the direction? What kind of argument are they trying to make against Karen Read? And I think that they really don't have one. And I think that's the biggest issue that they do have. The facts and the evidence are not on their side. Once again, it's a prosecution that should be on the offense, but is playing defense. And you're going to see a lot more of that as the trial continues. And I think, this defense team is going to be awesome here on out. And get ready, buckle up, and pack a lunch.
Thank you, Mazza.
Yep.
I got another question for Mark. This could be a troll. I'm not sure. Michaela727 says, does Mark know something about the something precedent? Is that anything the defense can use?
Something related to Daubert and the Massachusetts thing with experts. I don't know off the top of my head. I mean, it's not language that we normally use where I am, but I've heard something about it, that it's something to do with Daubert and whether they can give an opinion, but I doubt it, but I don't know, to be honest with you.
Thank you, Michaela. I apologize. She's definitely not a troll.
No.
I just, with this KUMHO, I was just like, I don't know what this is. This could
No, it's a real thing.
It is a real thing. Thank you, Michaela. I learned something. I've never heard that. How do you say it? Is it Kumo? Kamo?
I don't even know. Like someone can Google it and they can tell us and we can talk about it.
Yeah. Tell us in the chat how you pronounce that one. All right. I want to thank you guys for being here. Thank you so much. Attorney Mark Bederow, Bederow Law, and Mazza Media. Follow them both on X and Twitter. It's great. 3M's back together tonight. Thank you guys for spending time with us. Have a great night. I hope you had a great holiday. I hope you had a great holiday weekend. 3 days. You guys take the 3 days? You do a cookout or anything?
Oh, you bet I did.
Yeah,
Oh, yeah. Hot dogs, hamburgers, corn on the cob, all that great stuff for sure.
Oh,
very
nice.
Oh, yeah.
Of course you did.
I got to get back on a healthy diet in a few days. At least I'm keeping up with my walking, Mark.
Yeah, but that's important.
Yeah. Can't keep up with the Celtics anymore. That's in a real sore spot. I hope you're doing well in New York. That's tough.
I was going to say, you guys, the morning tonight.
Well, watching the Knicks implode.
Yeah.
And then
that was nice. Right after they had a riot, basically, right?
Man, Indiana let them off the hook the other night. So
they did.
Better win tonight,
yeah. New York was tearing the city down over beating the Celtics in the second round. That's how depraved New York Knicks fans have been for the last 20 years. They've been in the finals since '99. They haven't won it since '73. It's my goodness. That was pathetic watching them celebrate like that. And we had a lot of injuries. We won't make any excuses, but I will say this: if you beat the Boston Celtics, you better win it all. I mean, if you're going to beat us, the champs, you better win it all. This is your chance. And now all of a sudden you're getting beaten up by the Pacers. But I feel the real loser in all this is the NBA because their ratings are going to be really tough without any top tier franchises in that. I mean, an Indiana Oklahoma finals is going to be a tough sell.
That's probably would be the smallest market championship, factoring in both cities in probably professional sports history.
Yeah.
I mean, that would be, obviously OKC is really good, but for a really good team, they're not fun to watch. There's different, they have low entertainment value with all the foul baiting and all the free throws. I mean, they're not that, I mean, Indiana is actually fun to watch because
Sure.
they're up and down, they're crazy. But let's be honest, from the league standpoint, they want the Knicks.
Yeah, for sure.
Save them. Yeah,
That's your cash cow right there. Yeah.
that'll bring up all if the Knicks win, then all the conspiracy theorists will come out and say it's fixed because that's
Yep.
what they always say. That
I
Correct.
really,
pro sports are fixed.
for years I had to deal with, the Red Sox and Yankees living in New York, and 2003, I mean, was just brutal. I mean,
God.
that was the low of low point, and obviously it worked out the next year, and
Sure.
running around drunk on the Upper West Side on 2004 was a lot of fun.
Yeah.
But the idea of like having to listen to because Knicks fans are actually really good fans, but they never win, as you said. And walking around this area, there's a lot of new crisp hats. You know what I mean? Like that.
Yeah.
Which is not a very good New York thing. Usually they're pretty hardcore, but
Yeah.
this place is gonna explode if the Knicks win, because what they were doing outside MSG for winning a second round series was, by New York standards, embarrassing. I mean, they were swinging from the lamppost, going crazy for winning a second round series.
Yeah. Unreal.
Yeah.
Oh my goodness. That would have never happened during the Patrick Ewing era. I mean, my goodness.
No.
Jeez.
No. But so let's hope the Knicks lose. Sorry if you
see the Pacers win. Yeah, go Pacers.
Yeah.
All right. Well, I'll thank you guys so much for being here, and they're already asking Mark. Will Mark come back tomorrow night? They're asking for Mazza too.
Are they?
They're already asking. Will you guys come back tomorrow night?
Well,
this is what happens to me. My whole life is about will Mark and Mazza come back on the show.
No matter how hard I get out of this thing, I always pull me back in. I feel like Al Pacino and Godfather. But Wednesday nights are no go for me. That's my martial arts night. Yeah.
So give you credit. You were quoting the only acceptable line in that entire movie. That very good, Godfather 3, which normally we don't even acknowledge.
We don't acknowledge the third one, no, except for that.
Don't like that one. That's not a good one.
No,
it's like Jaws 3D. Remember that one? Do you remember that
Jaws 3D was terrible. I mean, that was supposed to be like...
That was terrible. That was one of the worst. I went to see that in the theater. That was terrible.
Sorry to hear that.
Now that I have to say, well, because we talk about bad TV or whatever. So right now I am currently in season 3 of Yellow Jackets. Okay.
Okay.
And so no spoilers, people, but because it's like train wreck TV, I have to finish. I feel like it's a chore. When that show came out a few years ago, the premise was really impressive. It sounded great. These high school team crashes in the Canadian woods and they go all Lord of the Flies and survival. And all right. So the first season of that show was really good. It should have been a 1-season show, though. It has now gotten so ridiculous. You don't watch this show, I assume, because you're looking at me like I have 3 heads. Yeah. Okay. It has gotten so bad. Don't watch it if you don't know
it.
Okay. That didn't land. Hoping it would, but
that's all right. No, I've never seen that show. I think I might have heard of the name, but I've never seen it. I've seen Yellowstone, but that's a totally different show
in the beginning. But 3
seasons.
It
was really good in the beginning, but it's gotten ludicrously dumb to the point where I feel compelled to watch just because, I told my wife, can we just like watch the reviews and I'll know what happened without having to sit through hours of this god awful TV. But anyway.
There where you're caught in a season, you're like, do we really have to watch?
I actually tonight need to watch the finale of A Handmaid's Tale. That came out yesterday, and that show, you should watch it.
Which one's that one on?
That's the one with Hulu. Elizabeth Moss.
It's Hulu, okay.
That show started really good. It kind of got lame in the middle seasons, but it picked it up, and it's like really good. And actually, I think I'll watch that tonight. Very good. And it's ending finally after like 6 or 7 years, whatever it is. It's not Breaking Bad, but it's good.
Not Breaking Bad. Not Breaking Bad. Yeah.
It's...
I still love Ozark. That was like my
Ozark.
Yeah, I just love Ozark. I wish they would do another season. Even though it
Ozark,
got ridiculous at the end, I just like love that show.
Ozark to me was, I mean, obviously it's nothing like Breaking Bad, but was the closest feeling of watching a Breaking Bad type
Right.
show.
Exactly.
Good
Very
cast.
similar.
And there were moments. I mean, look, obviously in Breaking Bad, especially near the end, was some of the most, oh my God, shocking, heart pumping television. I mean, there was a few episodes, you know what I'm talking about if you're a Breaking Bad person, where, I mean, it's the most intense TV you would ever see. And Ozark had a few like really unpredictable, gratuitous violence moments where you just fell out of your chair and didn't see that coming. And, you know, so it was good.
The TV sucks. I agree with you. TV sucks. We just talked about it for 10 minutes. We love it though. I don't know. I could say one minute I'll say TV sucks and I'll say TV's great. I mean,
You're right. Yeah.
it's all
Stop
subjective.
flip flopping, Mike.
Yeah, I'm a flip flopper totally.
It depends
I
on
know,
the
that's
show,
what-
I think. I mean, it depends on the show. If you like a lot of shows, or if you don't, then it's gonna
Even if I
vary.
like them though,
Yeah.
I think it sucks because I'm like, look at all the time I wasted watching this. That's
Right,
why I
yeah.
feel guilty. I don't know.
Right. Yeah.
It happens.
Yeah.
I
Yeah.
watched a series a couple of weeks ago that I was, well, I shouldn't say I was forced to watch. That's not quite fair. But it may have been literally the worst show I've ever seen, ever, on Netflix, called The Four Seasons. It was, God, it was so bad. And they renewed it for a second year, and I don't know why.
Somebody's watching it.
Yeah.
Somebody is, unfortunately.
Yeah.
Landman's one of my favorite shows. Tulsa King. Those
Tulsa
are two of
King,
my favorites right there.
Tulsa King.
Right.
Yep.
But Stallone is old. But
He
it's
is
all right.
up there now. Yeah, he's like in his
Yeah.
Clint Eastwood.
You know, this is
Yeah,
like now
that's a little too much of it now. Yeah.
like old man. It's
Yeah.
not the same. Yeah. But I love it.
See, there she is, Sarah in Shock and Horror, one of our mods here. She liked the Four Seasons. She said, blame me for the renewal.
Mike, I'm telling you, unwatchable. It's meant to be funny. It's not funny. It's meant to make you feel, oh, relationships. It doesn't. It is just god awful TV. Don't watch it.
This is the one, someone just said, I like Dexter too. That was the one. I like Dexter, but it got too much after a while. I was just like, my girlfriend's like obsessed with it. And
I
it's
like
just like, do we
Dexter.
really have to watch this one, the season 2? Please, no more Dexter.
I tried to watch the new one, and we watched because I like the original one.
Yeah.
The same type of, and we aborted like 30 minutes and like, yeah, I'm done.
Oh,
That's
geez.
where I got with Dexter
Yeah.
after a while. Just like,
That
no
happens,
more.
that happens.
No more. It's just
Yeah.
too much.
Yeah, it was the same thing. And, you know, setting up a kill room and watching them carve people up. I mean,
It's like it was kind of exciting show at first, but then after a while, you're just like, again,
Yeah.
No, I don't want to see that.
Nope.
Oh, it's funny.
It's
But
funny.
it's like someone said, different strokes for different folks. We all got different, interests and flavors that we like.
That's
so
right.
it's
Yeah.
great. I want to thank you guys all for being
Thank you.
here again, and have a great night and enjoy your TV tonight if you get to watch some TV, and
Right.
maybe we'll
NBA.
root for the Pacers. NBA, go Pacers!
Yeah. All right.
Take care.
Thank you guys. Have a great night.
Bye.
Bye-bye.
I
Free
know.
Karen Reed.
Free Karen Reed. We're the Young Jerks. My name is Mike Crawford. You know, I just want to go through the super chats real quick. I just gotta let you know, we did put it up on the screen. We don't do the money for super chats when Mark's on the show. We just do them only through non-paid super chats. So next time, just drop the question in the chat. Thank you so much for the donation. When can we have you three back? Tomorrow, please. I did ask him that question because everyone was actually asking that. Thank you, A, for asking that question tonight. Melissa R said $4.99, said drop my 16 Pro Max 3 foot down onto ankles, left a massive bruises and swelling for weeks. Wow. Yeah, it's amazing what will swell up your and leave bruising and what won't, right, Melissa? Leah M says same clothes, hat, shoes as Officer John O'Keefe. Was weird, right? Yeah, that was weird today. Definitely weird. Texas Prime said $10. Said I was unimpressed that Welcher said he didn't care and had no skin in the game. Shouldn't care and take pride in his work. Am I just being nitpicky? Thank you, Texas Prime. Stacy LaBruno sent 4.99. Says the Commonwealth owned witness said we don't know when a collision could have happened. Done. I know, right? We don't know. Kelly Carolyn, she's been a member for the last 11 months. She says, what about reading Karen's medical files? Good question. Brooke Palmer sent $10 and said, will the defense be able to present that ARCA was originally hired by a separate law enforcement agency, like they said when asking McCabe about the feds? Always great watching you guys. Thank you for the question and the $10 super chat tonight. Brooke, we did ask that a similar version of that question tonight. It was asked. Thank you for sending the super chat. Next time, if you do want a question asked during the show when Mark's here and Mazza is here, just drop it in the regular chat. You don't have to send it $10. Liz Swift sent $5. Said, who is Brennan Lally Canoni protecting? How wide and high does the corruption go? Good question. None of us know. None of us know. I just think it all goes back to protecting Morrissey. That's my as high as it goes. Sarcastic Warlock says, my time as a dummy, the memoirs of Judson Welcher. That, that would be a good memoir. I'm sorry. Speedy Lee sent $5 and said he should try the reenactment again, but this time a little faster, for science. Yeah, maybe more than 2 miles an hour. Angie's Wave said $4.99 and said, thank you for your time. Mike, please see post your fun site ward off the trolls you're dealing with. Appreciate all of you. What? I'm not sure what that one's about. Thank you for your time. Please see post your fun site ward off all the trolls you're dealing with. Maybe you're looking for the link, maybe for the fundraiser for my defense fund, maybe. I did pin it in the chat just a few minutes ago. If anyone wants to kick in on my legal defense fund, I am being sued for defamation. It's crazy, ridiculous. Not really worried about it, but I really do appreciate everyone stepping up to support us because it does cost money. I spent $10,000 on it already. Canoni Rucourt sent $2 and said, Mr. Bederow, who did better, Trooper Paul or Welcher? Standing Stone 1776 sent $5. Can you ask Mark about the hand signals? I would have loved to ask him. You gotta put those questions in the chat, not the super chat. We're not doing the super chat questions. Barbara Sturbeck sent $10 and said, when they showed her car backing up into John's car, how would a broken out taillight show the same on both sides? It was glowing red, yet it was broken. Am I crazy? No, I don't think you're crazy. Kevin sent $5 and said, how about that small piece of glass on the bumper traversing how many miles in gale force winds in the blizzard? Now that's science, I know, right? That's one that's always come up. We've always brought up on the shows. Like Mark's brought it up a lot. How does that glass stay on that bumper? You know? Just me sent $5 and says, is it concerning that his CV on company site reads not for expert designation? I'd say it's concerning for their company. Probably concerning on the cross tomorrow too. Dye and Medfield said Bev only told the jury to disregard when Alessi spoke up. Would a good judge nip it in the bud and not wait for it on objection? Thank you, Dye and Medfield. Ghosted Mr. Higgins became a YouTube member. Thank you so much tonight. Thomas Futch sent $5 and said, no neighbors have any surveillance footage. Not that we've heard. I'm not sure how much they asked. Hmm. Okay, and unless he bring up Trooper Paul's theory that John O'Keefe put his arm out and was struck, as opposed to Judd's new theory of him rolling. Yeah, he definitely can. Why wouldn't he be able to? He can ask the witness about it. Thank you, Victory, aka 86. Thank you, Queen Olive and Scooter. He got the body paint at his strip club. That's funny. I don't know. Did he? Connie B. I don't know if the girls would give him anything. Shelly, I'm Sharp Media. Thank you so much. I hope this is the real Jane Jackson tonight. I'm gonna check right now. The other night we had an imposter James Jackson in here. I had to block him out, kick him out. I think I've done that twice now, but I think this is actually the real James Jackson. I'm gonna check. Let's see. Let's see if it's the real deal. Yeah, that's the real James. Hey James, how you doing? We love James and we love JFK. I'm gonna check the Venmo real quick. I know I had some Venmos earlier too, so might have a couple here. All right, I want to thank Barbara M. She sent $20. Thank you so much, Barbara M. on Venmo. And Joan H. Sent 25. She said to help with the costs related to your case. Thank you for all you have done. Oh, thank you so much, Joan H. I really appreciate that. Mary C. Mary C. also sent $50 the other day, and she said, "For your legal defense fund, love you, Mike. You're the best person." Thank you, Mary C. I really appreciate that. And also the other day, I had with the Nan show, I got a donation on Venmo from Kelly L. She said, "Thank you, Mike and Nan." So I want to thank the two Colleens. They both sent $50 the other day. Colleen K and Colleen E. Thank you so much for the $50 donations. Oh, actually, one of them sent 25. Excuse me. But thank you for the donations the other night. Very much appreciated. And thank you, Russell S. He sent $10 tonight and said, "Thank you for all you do." That was on the Cash App. Right. I also want to thank everyone who's been donating on that defense fund. It's been amazing. I just can't thank you enough. Knowing that no matter what happens in this, I'm not going to run out of money on this. You guys have got my back. It makes a big difference. And the biggest thing is it's such a morale booster. I've never been sued for libel. I've been doing this for decades. And to have this happen now, it does suck during the Karen Reed trial. It has kind of thrown me off a little bit. But to see all of you stepping up to support us like this and just how quickly a lot of you did it with no questions asked. I'm just kind of blown away by it. And it's over $7,000 already. I'm very thankful. $7,928. I just thank you so much for doing that for me. Also going to definitely, probably, hopefully do some more fundraising for Karen and Aiden Carney as well, like we've been doing the whole time, and maybe do something for all three funds upcoming, where you just decide which fund you want to donate to. But I'm very thankful that you have all stepped up. So many of you. Look, I mean, this is just 209 people have given in just like 3 days, basically. So I'm just almost at 8,000. That's just unbelievable to me. $7,928. Wow. Thank you so much for doing that. If you can, please hit like, subscribe, follow, and we'll see when we'll be back tomorrow morning. Definitely, we're gonna be streaming in the morning. I don't know if it's gonna be 9 a.m. or 10 a.m. I know the jury is supposed to come back at 10 a.m., but hopefully Bev starts at like 9:30 a.m. maybe, and hears from the attorneys and gets everything situated early. But we'll see what happens. We'll be live streaming it tomorrow morning. Definitely see you there. And if you can, make sure you follow Mazza Media, follow and like him on Twitter and YouTube, as well as Bederow Law, who's on Twitter, who I'm sure you're already following. But if you're not, definitely do so. I want to thank our moderators, MJ, Sarah, and Shakanhara, Stephanie, Jeno, I saw her donation come in on my fundraiser today. So thank you so much, Jeno. I love our ladies in the chat. The ladies in the chat, they kick ass. Our four ladies, I'm so thankful for them. And they've had my back this whole time. They've so helpful to me. It's such a resource for not only myself, but this entire chat, this little group that we have. And thank you to the ladies in the chat. So I'll see you tomorrow, maybe. Tomorrow in the morning. 10 a.m. I think it is. We'll see you tomorrow morning. Have a great night. Oh, thank you, Sarah. We'll see you tomorrow.